Hello and welcome to Quadcast, Quadrant Chambers weekly discussion forum, looking at news, legal developments and hot topics in the world of commercial litigation. The format is very simple: drink, talk, chat. Drink, we'd like you to join us in a drink. I've got a delicious gin and tonic. Talk, we're going to talk about a legal topic each week. And chat, we want you to join in the debate. You can send us your questions, comments, observations to quadcast@quadrantchambers.com. Or you can join in on the chat facility on YouTube if you're watching on YouTube Live. So this week on Quadcast, we have the team together: Poonam Melwani, Joe Sullivan, and Claudia Wilmot-Smith. Poonam, what have you been up to this week? What's been occupying your thoughts?
Well, actually, I have Joe to thank because he's given me some real inspiration. Last week, Joe mentioned that he's been spending quite a lot of time at the piano that we can see behind him playing some Chopin. And I used to be really rather good at an instrument, but I haven't played it for 28 years. But having listened to Joe last week, I started to play it again this week. But in order to encourage our audience to start using the chat function and communicating with us, the game I'm going to play is you have to guess my instrument, and I'll tell you at the end what it is. So start sending in your answers, people. But in the meantime, Paul, what do you think it is? What's my instrument?
Didgeridoo.
For God's sake. Joe?
I'm going to go with spoons.
I don't know what the hell you two think of me.
Claudia, I'm not taking your abilities very seriously.
I'm a little bit offended here, people. Claudia, you're not allowed to guess because you're my people, and I think I might have told you.
I think I remember when I was helping your son with his piano practice.
Okay, yeah. Joe, what's been going on with you this week?
Well, I've been riveted, as I am often, to Elon Musk's Twitter feed, which is an extraordinary rollercoaster ride at the best of times. I mean, this week, when he hasn't been tweeting provocatively with the seeming intent of tanking Tesla's share price, or announcing the name of his new baby, which is X-Ash A12, he's been developing a bromance with our very own Lord Sumption. Specifically, Lord Sumption has been setting out some fairly trenchant views about the government's response to COVID-19 and its impact on civil liberties. And Elon Musk, it turns out, is a huge fan of all of that. And it seems to me it screams out, once this is all over, for a talk radio tag team, perhaps a title, something like The Pungent Musk of Justice, I thought, which that wasn't quite the reaction I was hoping for. But, they could have a line of aftershave and everything. Anyway, Claudia, what have you been doing?
Merch opportunities are endless.
Claudia, what have you been up to?
Most people will be aware to some degree, Meghan Markle is suing various UK, I don't know if I want to call them newspapers, tabloids, for breach of privacy. Extracts of a private letter she wrote to her dad were printed. And I saw this headline, opening legal battle. It was actually, I thought, quite an exciting way to describe a strikeout hearing where the judge ruled that some parts of the pleading weren't necessary to the pleading case. But as well as learning about that, the letter also said that the Daily Mail's defence was she can't have expected the letter to remain private because if she had done, she wouldn't have made her handwriting so neat. Now, that may be playing with the truth as much as the headline was. I don't want to say that actually is their case, but if it is, I'm quite entertained by the handwriting defence. How about you, Paul? What have you been up to?
It was a good case, though, for a strikeout, wasn't it? Because the judge took a fairly robust line in terms of pleading extraneous material.
Actually, it's the kind of case it might resonate with those of us who have American clients who take a different approach to pleading than England. A lot of it was struck out. He said, all these allegations of dishonesty, prej thrown about, they're not necessary. We've seen worse, more sternly worded judgments by Leggett saying much the same thing, but it did seem having an American client can pose a issue in the Chancery Division.
What I saw, what caught my eye was there's been this recent, this very quick, urgent review of the civil justice system in the light of COVID-19. It was started last Friday, 1st of May, and the review period is until next Friday, the 15th of May, and there'll be a report issued by Dr. Natalie Byram, Director of the Research at the Legal Education Foundation, on the 22nd of May. And it's looking at the way that the justice system has responded to COVID-19. Master of the Rolls Terence Atherton says, essential we understand quickly how court users are being affected by the widespread changes adopted by the system in response to the crisis. So people can, if you go to the HM Court's website, details of the review there, if you want to give feedback, you can do so. Feedback from last week. Thank you everybody who's watching. Thank you for your emails, your messages. Just a couple I thought I'd read out. Ian Gascoigne says, very much enjoyed watching today's Quadcast, so much so I watched the recording of last week's immediately afterwards. I thought it was relaxed but instructive half-hour, persuasive advertisement for the strength of Quadrant Chambers. Well said, Ian. I couldn't say it better myself. And this one from Tony Guys at Disputes E-Filing. Just watched this, thought the format informality was all great. Well done, the presenters. Very slick. By the way, tell Claudia the cat needs to have greater visibility next week. Things we need to know: what's the cat's name? What are the views on the issues discussed? What is your cat's name, Claudia?
This is really shaming. I didn't think I have to say this live. My cat is called Spartacus.
Spartacus.
Which is a good name for a cat.
Very good name. Very good name. So this week we're looking at vicarious liability, 2 Supreme Court decisions out on the same day, like London buses. And Joe, why are we interested in vicarious liability?
Well, it's an important principle really across a number of different areas of law. I guess people typically think about it most in connection with tortious claims. But in fact, it applies much more broadly. It comes up in fraud cases, in contract cases. And of course, there is a real interface between vicarious liability and issues of authority. So it crops up a lot in agency cases too, like the Ocean Frost, for instance.
So, yeah, we're going to go through a few cases before we get to the Supreme Court decisions. By the way, Julie McHale, Poonam, says harpsichord for your instrument.
I'm
No
not
reaction.
till the end whether people are right or wrong. I hope that's not the only guess so far. Keep it coming, people, but it's better than whatever you guys said. Spoons and what did you redo? Okay.
Anyway, we're going to start the cases with a decision Privy Council in 2004. This incident occurred at the Kingston Central Sorting Office. We should have a picture that we can flash up on screen. That is the Kingston Central Sorting Office, like the General Post Office in Kingston, Jamaica. What happened there was Mr. Barnard, who was a 32-year-old male, had gone down to the sorting office with his parents to make a long-distance call from the phone booth. That's what you had to do. That's where you could make the calls from. And such was the demand for this phone booth that there was a queue. So he was using the phone at the front of the queue, and there were 15 people in the queue behind him. Up steps Mr. Paul Morgan, who is an off-duty police officer, not wearing his uniform, no sign that he's police, marches to the front of the queue, says to Mr. Barnard, come off the phone, I want to use it. I'm the police. And Mr. Barnard refuses, so Paul Morgan remonstrates with him a little bit and then takes out his revolver and shoots him in the head. Shoots him through the left side of the head, goes in and out the other side. Miraculously, Mr. Barnard survived. Question is, are the police force vicariously liable for Mr. Morgan's actions? The courts below said no, but the Privy Council, strong Privy Council, Lord Bingham, Lord Steyn, Lord Millett, Lord Scott, Lord Carswell, all said, yes, they are liable. Even though, remember, he's off duty, he's not wearing a police uniform, there's nothing to do with or connection with his job so far as the truth is concerned. So that's Barnard. And we'll come back to Barnard and cases like it, because I want to demonstrate something when we've looked at the Supreme Court decisions. But I think, Joe, you're going to go next with Lord Nichols in Majowski.
I'm looking at Lord Phillips in the Christian Brothers case back in 2012. That was a case where the allegations were of physical and sexual abuse in a school. And the question was whether the Institute of Christian Brothers was vicariously liable for their members who were teachers at the school. Now, Lord Phillips looked in that case at the policy reasons for having vicarious liability in the traditional context of employer-employee, but also more broadly. And he identified 5 policy indicia, which he said were relevant. The first was that an employer is more likely to have the cash available to compensate a victim or insurance in place. The second was that the tort is likely to have been committed as a result of activity undertaken on behalf of the employer. The third is that the activity is likely to have been part of the employer's business. The fourth is that the employer has, by employing the employee in that particular position, created the risk of the tort. And then lastly, that the employer is likely to have had control over the employee. Now, those were put forward as policy justifications for the existence of the principle, but subsequently, and indeed in part in that case itself, they were really transformed into being the principles, that almost the test for whether there should be vicarious liability in any particular case. Now, Claudia, I think you looked at some more recent...
Before we go to Claudia, can I just ask you, there are two questions that arise in vicarious liability, and we're going to look at both of them. The first is the person an employee or someone like an employee, so that it's the sort of person you can be liable for? And secondly, is the thing he did a frolic of his own or in the course of employment? Did Christian Brothers deal with both those issues, and was Lord Phillips using his 5 indicia for both of those issues?
Yeah, it covered both. So in that case, the question was both about the relationship between the institute and the teachers, but also the activity and whether that was an activity which should give rise to vicarious liability. And the 5 policy indicia applied generally to the principle, as I think your cases showed, Claudia.
Right. So in 2016, there was another day when the Supreme Court gifted us with 2 decisions on vicarious liability in the same day. 2020 is not the only happy year on that front. And they were handed down one after the other, and they answered these 2 questions that Poonam identified. The first case answered the first question, and it did so by reference to these 5 policy factors in a way the second case didn't. I'll get to that one later. The first one was Cox and Ministry of Finance, and this was the is he an employee question. In that case, the claimant was working as a catering manager in a prison. She was moving supplies with the help of some prisoners, and one of them dropped a really heavy bag of rice on her. She was injured. She sued the Ministry of Justice for negligence. She said they were vicariously liable for the prisoner's negligence. The MOJ doesn't actually employ prisoners, right? So they were carrying out work as part of their sentence. The question was whether they can be vicariously liable. So that precise question, the prison scenario, might seem like it's not super relevant to most of us, right? That's not the kind of situation we're used to dealing with in our practice. But the factors considered by the Supreme Court in concluding that the relationship was akin to employment, which was the test, are factors that I think are relevant in any kind of workplace. So the prisoners would...
We are going to have to acknowledge, Claudia, that there's a new guest appearance here.
Oh, my cat's been chomped.
Your cat's no longer the star of the show. Claudia, carry on while poor Joe deals with it. Phoebe, isn't it? Carry on, Claudia.
Yeah, so here, the prisoners were trained, they were managed, accountable, they could be dismissed for their work wasn't up to scratch, and their hours were managed by the prison. They couldn't choose the hours they worked. In that way, it was akin to employment. And their work was necessary for the running of prisons, right? They were working to further the MOJ's business, not their own interests. And if the prisoners hadn't been doing it, someone else would have had to. So the court thought it would be unfair to let the ministry have the benefit of this work without imposing the usual burdens of employment. And those include vicarious liability. The second case considered the slightly more difficult question as to the relationship between the wrongful act and the employment, and what relationship is necessary to impose vicarious liability. And that was Morrisons one, a petrol station attendant case. So the claimant, Mr. Mohammed, went into a petrol station. He had some documents on a USB disk, and he asked Mr. Khan, the attendant, whether he could print them. Mr. Khan said, "We don't do that shit." Not my language, that's a quote from the delightful Mr. Khan. And Mr. Mohammed complained about this language to him, at which point Mr. Khan told him to leave using violent, threatening, racist language. the claimant did leave. He went and he got back into his car, and the petrol station attendant followed and beat the crap out of him. That is my words. The Supreme Court said that he subjected him to a serious attack involving punches and kicks whilst the claimant lay curled on the petrol station forecourt trying to protect his head from the blows. So the question was whether those actions were sufficiently closely connected to work as a petrol station attendant to justify imposing vicarious liability. The Supreme Court actually considered whether that was the right test. It had been argued that it was inappropriate, but they decided that was the test. And when considering this close connection, contrast, a petrol station is employed to interact with customers, but he's not in the same position as someone like a bouncer or maybe a barman dealing with like drunk people and refusing them. He's not employed to carry out the kind of interaction that might foreseeably lead to confrontation, let alone violence. And so the fact that that wasn't the kind of interaction that he was employed to do had been determinative up to the Supreme Court. They said the connection wasn't sufficiently close. Lord Toulson disagreed. He said there's a two-stage test. First, you ask what kind of job they're doing. Then you ask whether there is this sufficient connection that it's right to make the employer liable as a principle of social justice. So he was applying the same test as the Court of Appeal. He reached a different decision. And it was a good Court of Appeal, right? It was Christopher Clark giving the lead judgment. And so you'd think, given this discrepancy, Lord Toulson would give good guidance as to what degree of connection is sufficient.
Well, I think that's the problem we now see in the two Supreme Court cases that came out.
Exactly, there was no guidance.
So in both cases, it was the same five. Yeah, it was the same five judges who gave the judgments in both, unanimous with one leading judgment. And in both cases, they overruled the unanimous view of the Court of Appeal and the judge of first instance. So took a different approach. The first case was Barclays, where Lady Hale gave the leading judgment. And the facts were these. Barclays, when they employ someone, send them to have a medical with a Dr. Bates in order that they can get medical insurance from them. Dr. Bates was in private practice. He worked for Barclays, he worked for others, but he'd be paid a fee per person that Barclays sent him, and he filled out his report on the medical condition on a Barclays tailored form. Regrettably, it then was alleged much later that over a period of some 14 years, Dr. Bates had sexually abused tens of thousands of these Barclays employees who'd gone for a medical test. So the question for all the courts in that one, Dr. Bates was not an employee, but was his relationship sufficiently akin to employment that Barclays should be vicariously liable? And the Supreme Court said no. And they said that people were wrongly using the five indicia that Lord Phillips mentioned and that Joe's told you about as the test. They said you don't get to those unless it's a really fine balance. First, you look at the nature of the relationship. So you look at things like wages, the amount of control, the structure, and for me, the most important point, whether the individual is carrying on activities as an integral part of the company's business or whether he's doing it on his own initiative and as part of his business. So answer from Supreme Court was not akin to employment because he worked for other people, Barclays didn't have control over him, he wasn't on a retainer. Might not find that one too difficult, but the next one is difficult. And this was the case of Morrisons, where Lord Reed gave the opening, the leading judgment. So Morrisons had a chap called Mr. Skelton, whose job was to manage the personal data of Morrisons' employees. And in particular that year, to collate all the personal data, bank accounts, names, date of births, addresses, national insurance numbers, and give them all to KPMG, the external accountants, to do an external audit. But Mr. Skelton was a little bit annoyed with Morrisons because he'd got a bad review and a disciplinary warning. And while he was at the office, he downloaded all this personal information onto a USB stick, then tried to cover his tracks by getting a fake phone, a fake email address, and also using software to hide his IP address, downloaded all the data information about these 100,000 employees onto a site that could be publicly accessed, also sent all the info to newspapers, inviting them to publish the story, all because he wanted to cause trouble. the newspapers didn't publish. Morrisons were alerted. A lot of the data was taken down very swiftly, but then 100,000 or so employees of Morrisons sued them for distress for their data having been out there for a while. And the question was, well, is this the sort of act that you are responsible for, or was it in the course of his employment? And the Supreme, you might think, I mean, hold on, this guy was given the data as part of his job. His job was to use the data and give it to KPMG. And the Court of Appeal said, so this is very much, there's a close connection between what Mr. Skelton's employed to do and what he did, which was give it to a third party, but a wrong third party.
Closer than kicking the crap out of a customer to me.
Sorry, say that again?
I said it seems closer than kicking the hell out of a customer to me, right? So I can see why the Court of Appeal got there after Morrisons won.
Yeah, absolutely. And they said the question is close enough connection for it to be fairly and properly regarded as part of employment. But what the Court of Appeals, House of Lords said was, don't take words out of context. And judges, this is not an open invitation to impose your own view of social justice. It's got to be principled. But then on the facts of that one, they go, it's not principled to do vicarious liability because Mr. Skelton was not trying to further Morrison's business. The chap who hit the guy on the forecourt of the petrol station, it was all about trying to get this guy away from the business premises, didn't like the way he was behaving in the business premises. This was vengeance against Morrisons, and I think that was a very important factor in the Supreme Court's decision, that it was anti-employers' needs. So they held not vicariously liable.
But the thing is, surely, that a lot of these decisions are, I mean, it's classic hard cases, bad law. They're irreconcilable. So take my case of Barnard, where it's held, very strong Privy Council held there is vicarious liability. Compare it with the Attorney General for BVI versus Hartwell, which is another Privy Council case, which is where another police officer goes round to a bar and shoots, again, somebody that he's got an altercation with over his girlfriend, held not vicariously liable. See, this is, let me give you my my synthesis of this, and then we'll look at a case study. But my synthesis of this is there are two competing theories. The first theory is risk creation, and that explains cases like Lister. And in case, I mean, the Barnard case that I mentioned at the very outset, they say in terms, an important factor was the relevance of the risk created that the police authorities gave him the gun in the first place. So you've got the risk creation theory, and then you've got another competing theory, which is authority-based, which is, were they acting in the course of their employment, or was the wrong closely connected with the employment? And that explains the sort of Morrisons approach. But the problem is that you've got these competing theories, which mean that the law is in a bit of a mess, I think, anyway. I mean, what do you, Poonam, any sense in that?
Well, if you have the Supreme Court unanimously in two cases overruling a unanimous view of the Court of Appeal, where the Court of Appeal is professed to apply two Supreme Court decisions of just 4 years ago, I think we're in a bit of a mess. So agreed, but there are really difficult issues here because so many sexual abuse, has created a whole reason to create vicarious liability. There are difficult issues that arise in these, so it's very difficult to just fix a hard and fast rule. That's
so let's have a look.
Lawyers.
Let's have a look at a case study which we've sent out to everybody who's registered for this. So we've got this case study. It's a firm of solicitors, Stubbs and Stiles. If we can put the case study up on the screen, what we've got is that an employee of Stubbs and Stiles goes to a client's address to carry out a specific disclosure exercise. And in the course of the exercise, there's mention of a safe. But at the end of the day, the client asks the solicitor, would they like to stay for a gin and tonic, end of the day drink, which they do. And after hours, the client, the solicitor is able to see the combination used to get into the safe. Solicitor goes away, then comes back later, breaks in and steals the valuables.
Paul, it may or may not be relevant to the answer, but let's also make clear that they were there for a disclosure exercise, and the safe also had some of the documents the solicitor needed to see.
Yes,
also had the diamonds.
Yeah.
Okay.
Now, before we go in, I'm going to go around in a minute and ask people what they think. But you watching on your laptop at home, you can vote on this one. So if you go to www.uk www.quadcast.vote. www.quadcast.vote. It should be coming up on the screen now. If you go to that website address, you will find a single page. You just click yes or click no for whether the firm's liable, and we'll give you the results a little bit later. But let's go to, I don't know, Claudia first. What do you think? Liable or not liable?
Oh, wait, can I just wait a minute, Claudia? You should say, Paul, to further embarrass us with our answers, we asked Chambers to vote on this. We asked them not to read the cases, but just give their gut view. We don't know the answers of what Chambers have said.
Well, I was going to say that as a
before the law's clear, we should all agree. And so if we disagree, is it because the law's not clear, or is it because we don't know it?
Well, if we all agree, it's because the case study is not very well drafted, is the truth of it.
Anyway, Claudia, I interrupted. What's your view?
Yeah, I don't think they're liable. I think it's a Morrisons 2 type situation. I don't think there's sufficient close connection.
Joe?
I think they should be liable.
Why?
Because the opportunity for the theft arose because the victim had allowed a trusted professional into her premises, and as between her and the firm has the opportunity to check whether this individual is honest. She doesn't have the same opportunity, and so it's fair that the loss should fall on the firm rather than the victim.
Poonam, what do you think?
I noticed Joe said he should be liable, not would be held to be liable, and that sounded like Lord Phillips's indicia rather than the test. I'm with Claudia. He would not be found. They would not be found to be vicariously liable if the opportunity arose that there is not a close connection between stealing diamonds out of hours and the job he was doing.
Yeah, I agree. But this risk allocation reasoning that Joe's using, that is the kind of reasoning that Lord Toulson used to get to his decision in Morrisons 1. And in theory, in Morrisons 2, the Supreme Court said that's still good law, and they purported to apply it. So it's the kind of reasoning that has won in the past. I don't agree with it, but that's a different point.
I prefer the risk allocation, the risk creation theory. That, to my mind, because I always thought Lister, when it was going up through the courts, I always thought there should be liability in that situation, yet the law on a strict reading suggests not so. I think not liable in this situation.
I think not liable, but I think Lister would be, if there's liability, I think that should be on a non-delegable duty reasoning rather than vicarious liability.
See,
and I think that's partly why we've got in such a mess. But what did Chambers say? That's what I want.
Hang on a minute. I just want to
sidetracked by the sexy law, but I want to know whether I won the poll.
I want to point this out, that if you look at this problem and apply the competing theories, there's no way that you can argue that the solicitor was acting in the course of his employment. But if you think of it in terms of risk allocation, that's a far more informative, useful tool, I think. And I'd say not liable because I don't think they sufficiently created the risk.
But this woman would not have had the solicitor in her home. She would not have trusted him enough to open the safe in his presence if he hadn't been a solicitor that, from a reputable firm.
Yeah, bear in mind all the
I don't understand the risk allocation leading you to a not liable answer.
Yeah, I think risk allocation would lead to liable answer. I just don't think that's the way the law has developed since between 2016 and 2020.
Paul, you're saying risk creation. You're saying...
Yeah, I find that a more useful tool than was the solicitor acting in the course of the employment. I find that your gut feel is yes, the risk created sufficient. My gut feel is the opposite, but I find that actually is the real issue in the case. But anyway, Emily, you're going to Emily, our producer, is sitting on the results. We don't know the results, by the way, so we haven't been told. Emily, if you've got the results, if you can flash them through to us, that would be great, and we can announce them. And then yes. I want the result now, Emily, if you've got it.
And the results of the vote, right? Have people been voting?
Well, we'll get the results of the vote. Yeah, the vote now is closed, by the way, so we'll collate those for you. So the answer is, according to Chambers, overall, 72% said no, 28% said yes. We did a split between the Silks and the Juniors. The Silks, no, was 81%, yes, 19%. The Juniors, no, 72%, yes, 28%. So it's pretty much overwhelming, I think, Joe, against you on that one, I think.
Yeah, I mean, no one's interested in real justice anymore, are they?
Real justice.
And the sort of public vote, it's very roughly 33% say yes and 66% say no, roughly a 1/3, 2/3 split. So, yeah, again, Joe, you're in the. Do you want to have the last word on it, Joe?
I loath though I am to disagree with both my colleagues and the general public. I think everyone just needs to have a very hard look at themselves.
Well, now we have got a second case study, which I think we'll do very, very quickly. We're not going to do a vote, and we haven't got a Chamber's verdict on it. But I'm just interested to see people's answers. So in this one, if we can just flash it on the screen, this is 23 Old Essex Way, an entirely fictitious barristers' chambers for the avoidance of doubt. What we have is an altercation over COVID protection measures, and the receptionist who takes umbrage at the way that the office manager has been dealing with it is effectively destroying and not observing by the office manager's rules. And the office manager is so incensed, leaves the premises, goes to the receptionist's house, knocks on the door, the receptionist comes to the door, the office manager punches the receptionist in the face, receptionist goes to hospital. So the question is, liable or not liable? Poonam, you first.
Liable.
Liable. Claudia?
Not liable.
Not liable. Joe?
Not liable.
Yeah, I say not liable.
You never agree with me on anything.
I say not liable. Poonam, why do you say liable?
The office manager's job was to keep these COVID rules in place. He had a position of authority over her. The fact that he does it outside of the office that night is where the grey line works, but the grey line comes in. But I think the court would see it as him being on the job, furthering like in the Mohammed punch on the forecourt thing. He was purporting to be going about the employer's business because the fury and the punch was because of her breaching the social distancing rules. So as mad as it sounds, I think it is. And there is also a case that's reasonably similar, the name of which escaped me. I'll answer it later. But yeah, I think it's liable.
It's a bit like Mohammed, but just a little bit further apart, isn't it?
But there's another petrol station attendant case that they talk about in Mohammed. And the reason I'm saying it is this thing that you said that gave the grey line, Poonam. This was a petrol station attendant who got in a fight with someone, just a verbal altercation. The customer left. Then he saw a police car. He flagged down the police car, got the police back, said, "This guy was rude to me." The police were like, "So this isn't a police matter." And then the guy said, "Well, in that case, I'm reporting you to your manager." At that point, the petrol station attendant was so pissed off, he punched him in the face. And there they said not liable. Even Toulson agreed because he said it had been like separated from the original customer interaction. And I think here it's the same. Like there's that. I think if she punched her in the office, then maybe liable. But because she'd gone home and I think it was more frolic of her own territory.
Well, actually, we need to wrap up soon. But that's sort of related to a question we've had on the chat, which is on our first case study. Would it have made any difference? Well, it can only be to all of us. Would it have made any difference if the documents had been stolen? Let's assume it was documents stolen, not diamonds, and stolen while the solicitor was there. He hadn't gone home and come back. While he was there, he stole the documents. Would the answer be different? If it's the documents, and without him leaving, the answer is yes. I'd say vicariously liable. Guys?
Yeah, I agree. I think if he steals documents on the job, he's liable.
I'd agree.
But now you all agree with me. It wasn't me that was wrong, it was the question that was wrong.
That seems right.
Joe, you have all the makings of a High Court judge. Now, look, we've got to do the instrument. Poonam, have we got a photo or something we're going to put up?
We do have a photo. Can we get the photo up?
Oh my gosh.
That's really bad.
It's
there with all our faces. Okay, so it's my harp, everybody.
I nearly said harp.
That's so good.
I nearly said Irish harp.
We got harpsichord, which was pretty close in words, if not in instrument. I thought I knew, but I thought it was the trumpet, so I completely got it wrong.
Yeah, cello. George Dawson said the cello. Sorry, George, you're wrong about that. And Julie McHale, I think I mentioned Julie, said harpsichord. Okay, so that's this week. Now, this was going to be the last Quadcast. We were just going to do 3 weeks, but we are going to continue our lockdown continues. So next week, we are going to do a special focusing on part of what we looked at last week, particularly frustration and force majeure. So what we want you to do is to send us your questions, and we will construct the program around your questions. So what you need to do is email us at quadcast@quadrantchambers.com and tell us what questions you've got, little case studies, little examples. And what we'll try and do is build the whole program around your questions. So that's next Thursday at 5 p.m. And if you like these programs and you like the stuff that Quadrant are putting out, please do subscribe to the YouTube channel, and then you'll get automatic notification of further webinars and events like this and further Quadcasts.
Well, definitely put in your questions as soon as you can, so we have time to work them into case studies and think.
Yeah, we've got a production meeting on Sunday evening, so
poor Emily works so hard behind the scenes. So yeah, give her time to.
Yeah, so if you can get your questions in before Sunday, that will be especially welcome. That just leaves it for me to say thank you to Fisheye Productions, Ben Jacobs, who's made the whole thing happen, the live streaming, and Emily Saunderson, our producer in the background, who sends us rude messages like telling us to move on and get on with the show. Thank you very much for watching, and hope to see you next Thursday, 5 p.m. Good night.